Managing and working through California leaves of absence are one of the toughest things that employers have to do. They really have to be able to sort through which type of leave will apply in any given situation, provide the notice to the employee, and then make sure that when a leave starts in one area and crosses over into another, that they're tracking it properly. And many employers are getting this wrong. Why? Because we have overlapping leave laws of all types and sorts in California. Something as simple as a pregnancy leave. California actually has 3 different leave laws that overlap with one another. This includes the California Family Rights Act, the Pregnancy Disability Leave laws, as well as the requirements of paid family leave administered through the EDD. Making sure that we have an understanding on how these laws overlap and when they apply is a critical part for every business to be able to understand. California was one of the very first states in the union to adopt a mandatory paid sick leave law. We've implemented this as early as 2018, and the laws changed slightly over the last couple of years, but most recently, at the beginning of 2024, we took a large jump between providing our employees in the state of California 24 hours of paid sick leave per year, jumping all the way up to 40 hours of sick leave per year. This means that you as an employer must ensure that if you have employees in the state of California, that you're providing them with mandatory paid sick leave equal to 1 hour of paid sick leave for every 30 hours they work. So if you have a full-time employee who works for you, you're allowed to cap their accrual of sick leave at 40 hours per year. But one important thing that many employers have missed about the new changes to the law, you must report on every pay stub how much time an employee has accrued in way of sick leave and how much they have used during that pay period. Many employers are getting this wrong. They simply are neglecting to report the accurate calculation of the accrued sick leave or how much sick leave they've used during that pay period, and that creates a violation under California Labor Code Section 226A. One of the other most recent additions to California requirements is providing bereavement leave for employees. Under California law, beginning in 2023, an employer must make sure that an employee is provided with no fewer than 5 days of unpaid bereavement leave for anyone who has suffered a loss in their family. This can be extended up to 4 times per 12-month period, meaning that an employee can take up to 20 days of unpaid bereavement leave in a year if they lose multiple folks within their family. Even the smallest of employers have to abide by many of the leave laws in California. For pregnancy disability leave, you only need to have 1 employee. For California Family Rights Act, which provides 12 weeks of unpaid leave for the illness or injury of an employee or a family member, you only have to have 5 employees. That law recently changed. It used to be 50. So even the smallest of employers now have to make sure that they understand and are communicating the rights and obligations of every employee under the leave laws that are applicable to their business. So if you're a business in California and you have further questions or don't quite understand what the law actually is in the particular area we're talking about, contact us today at 661-362-0813.